Hi guys, it's Kathy. I hope you're doing well. Might go how many more days until you get to go home? Today? Or no, you can't go home in May. You said sometime in June? That sucks, Maiko. Maiko needs to go home, guys. Alright, we made it to Wednesday. 2 streams today. Yay. Okay. So, this woman thinks there's really no difference than hitting someone with a car than just hitting them with your hand. There's really no difference. I see Kelly's comments. Make sure it's on live chat. I know. I know you know. I know. Stupid YouTube. Stupid YouTube. All right, here we go.
R811. Okay. And any preliminary matters?
Judge, other than I'm going to need a screen for an exhibit, I don't have any preliminary matters.
Just a sequestration order.
And the court will grant a sequestration order pursuant to Rule 615. So any witnesses should be excluded from the courtroom. Are there any potential witnesses that either party notices? Don't have anybody on web apps.
Not from defense.
Not from the people either, Your Honor.
Okay. You may call your first witness.
People called Detective Brian Odell.
Nice Irish guy. This is just the prelim. This is not the trial.
You can raise your right hand. And detective, do you swear and affirm to tell the truth, the whole truth, and nothing but the truth under penalty of law?
I do.
You may be seated. Please make sure to pull up that microphone. Counsel, whenever you are ready.
Thank you, Judge. Detective, can you tell the judge your name and spell your first and last name for the record?
Detective Brian Odell, first name spelled Brian, last name spelled O'Dell.
What is your background in law enforcement?
Started into law enforcement in 2017, promoted to the rank of agent in 2021, and have been with the Domestic Violence Investigations Unit since.
Were you assigned this case?
Yes.
When were you assigned this case?
April 3rd, I was in an on-call capacity working for the Domestic Violence Unit.
How did this case originate?
The case was originated as incident where a male had been run over by a vehicle in a parking lot of an extended stay parking lot, or extended stay hotel, sorry, at around 7:45 in the evening on April 3rd.
How was law enforcement notified?
Law enforcement was notified by the witnesses who saw the incident. They had called 911.
What is the physical address of that location?
13941 East Harvard Avenue
Where is that located geographically?
in the city of Aurora in Arapahoe County.
State of Colorado?
Correct.
Who were the first officers on scene?
Officers Ourston and Vieira.
Can you spell Ourston?
I believe it's Hourston.
What did they observe when they got there?
They observed a male on the ground who was severely injured, and a gentleman, a witness who was nearby, stating that he had witnessed the incident.
Who was the individual on the ground?
The individual on the ground was a gentleman by the name of Antonio Bletcher.
And you said he was on the ground. Where was he?
I'm sorry, counsel, can he say that full name again? Antonio.
Antonio Bletcher.
Thank you.
Where was he relative to the extended stay?
He was on the north end of the parking lot, I believe on the other side of the curb, and some kind of curtilage and landscaping there.
When you say the other side of the curb, what are you talking about?
So he was up on the curb beyond like where the parking lanes actually are.
Did you review any body-worn camera relative to that first contact?
I did.
Did you make any observations about Mr. Bletcher's appearance in that body-worn camera?
I did.
What did you observe?
He appeared to be, like I said, severely injured. He was pretty much immobile. When he first started talking to Officer Ourston, he made the statement that his ex-girlfriend hit him with a car. Just something to that effect. I don't know if that's the exact words. But it was really hard to kind of decipher what he was saying, and he didn't really add much to that statement. As far as his appearance goes, was that a little bit difficult even to see in Officer Hughes's body camera because, his camera's pointing up and out, whereas, Bletcher was underneath him. So it didn't really capture a lot of the disfigurement that he had reported seeing in his reports.
Was there any other identifying information found at the scene as far as evidentiary matters?
Yes, there was a Chime debit or credit card on the ground that had Antonio Bletcher's name on it.
Where was that relative to him?
It was in the parking lot a short distance away.
You indicated that there was a witness there. What was the name of the witness?
Ethan Hahn?
What did Mr. Hahn indicate? And can you spell his last name? I'm sorry.
I believe it was Hann.
What did Mr. Hahn indicate he had seen?
Objection, hearsay.
I will allow it's a preliminary hearing. The rules of evidence are relaxed.
Ethan Hahn, as per his statement, said that he heard some shouting outside, came outside onto the upstairs balcony and saw a couple arguing. And I think he indicated over there and had directed the officers kind of to the east from where they were standing at the time of the interview. And he said that at that point in time, he saw the woman who was driving the vehicle relocate the vehicle over to another part of the parking lot where he kind of indicated in the interview. And then claimed that the male walked over to her. They had some conversation by the vehicle. And then as he went to walk away, he actually, sorry.
Let me pause here. You're using he's.
Okay.
So can you indicate the witness versus the victim in the
Okay, my apologies. Mr. Hahn indicated that the victim in this circumstance had walked over to the vehicle after it had been relocated, and that the victim and the driver of the vehicle were then exchanging some words. The male victim then went to walk away, and the driver of the vehicle, he worded it two different ways. The first time he said that she drove off and then turned around and hit him. Second time he worded it, he said that she had like turned into him. I'm sorry, Mr. Hahn said that she had turned into the victim and ran him over and just kept on driving.
What did Mr. Hahn do at that point?
Let's see here. Mr. Hahn
Maybe he asked her to.
approached Mr. Bletcher on the ground and called 911 and started airing information to 911 once they answered.
What did he say happened next?
He said that Ms. Burrell came back. He had mentioned that she came back multiple times, actually. And that when she did, he believed that it looked like she was going to hit him again.
Did he indicate how many times she came back?
He said 3 or 4 times.
Did Mr. Hahn, give a description of that person?
Mr. Hahn described her as a light-skinned black female with some sort of colored like head covering, like a headband or like a hair wrap, something along those lines.
Did he indicate if he had any conversation with this individual?
I believe he said that she had told him she would hit him again if he got up again. I also believe that she had made some sort of statement to him about how he had struck her And I'm sorry, when I say he had struck her, I mean the victim, Mr. Bletcher, had struck Miss Bureau while over in that other part of the parking lot.
Did law enforcement try and locate the driver of that vehicle?
Yes.
Who went to locate that person?
Officers Diaz and Winger.
Where did they locate the driver?
I believe it's 1045 Sable Boulevard.
Who did they speak with?
They spoke with Miss Burrell.
What did Miss Burrell indicate had happened?
Miss Burrell told them that she had gone to meet with Mr. Bletcher and had gone to return his credit card to him. And that they had been like fussing back and forth about the credit card and her use of it and the money that was being spent. And in the process of her trying to do that, she tried to hand him the card out the window. He had come around to the driver's side of the vehicle, opened the door, and then started to assault
I'm
her.
so sorry.
And she initially said that he slapped him. I'm sorry, that Mr. Bletcher slapped her, and then corrected it and said that he had actually punched her instead. And by he, I mean Mr. Bletcher.
What did she indicate happened next?
She said that after he hit her and after Mr. Bletcher hit her, she hit him with her car.
Did she indicate what she was driving?
She indicated that she was driving the Chevy Equinox that was in the garage, and she took officers down and showed them the car shortly after.
Subsequent to that conversation, did you have an interview with Miss Burrell?
I did.
And for the record, is she present?
Yes.
Can you identify where she is seated and an item of clothing that she's wearing?
She is seated at the defense table wearing an orange jumper.
Your Honor, subject to cross-examination, may the record reflect that he has identified the defendant.
Such cross-examination, the record will reflect.
Where did you speak with her?
At the Aurora Detention Center.
And what did she describe to you about what had happened?
She gave me a fairly similar statement saying that they had been arguing over her use of his debit card. She had gone to return it. He had come around to the driver's side of the vehicle, and by he, I mean Mr. Bletcher had come around to the driver's side of the vehicle, opened the door, and then struck her in the head multiple times, grabbed onto her braids, pulled her braids out. And then at that point in time, she just, like everything went out of her head. She just kind of started focusing on protection, and she hit him with the car.
Did she indicate or did you ask her whether or not that was an accident or something else?
I did ask her if that was intentional to run over Mr. Bletcher with her vehicle, and she said it was.
Did you talk to her about the difference in force between what he had used versus what she...
Slushy farm show weather is the perfect description. We have this huge farm show in Pennsylvania every year. Huge. Every year it snows. It's horrible weather every single year for the farm show.
she had used?
I did.
What did she say about that?
She said she didn't perceive any difference between a person hitting another person with their hands and a person hitting another person with a car.
Did she say anything about what her intent was when she was running over Mr. Bletcher?
She said that she did not intend to kill him and that she had circled back through the parking lot in order to verify that he wasn't dead.
Did you ask her, or, well, I'll ask her, did you ask her whether or not she called 911 after that?
I don't recall. I don't think I did.
Was there a record of her calling 911?
I don't believe so.
Subsequent to that conversation, did you try to ascertain whether or not there was any surveillance video in the area of this?
I did.
Were you able to locate some?
Investigator Materi was able to get some from the RTD camera system nearby.
Where is that relative to this location?
They have 3 to 4 cameras just to the north, east, and west of that hotel.
Does one of the camera, and did you review those surveillance footage?
I did.
And does one of the cameras show the vehicular assault where Mr. Bletcher is run over?
It does.
May I approach, Judge?
Yes.
Pretty sure what's been marked as people's 1, 1A, and then 2 through 4. Actually, 5. See that?
Thank you for the cheers, Kelly. Thank you.
Let's start with 1 and 1A. Do you recognize what that item is?
Yes, I do.
What do you recognize that to be?
It's a DVD containing the video footage that's still shot in these images.
What portion of the video footage does that show?
One of them, so exhibit 1 was just, I believe, like a 30-second clip. And then 1A is a 3-minute and 30-second clip of this camera view showing where Mr. Bletcher approached the vehicle. Some words are exchanged at the driver's window, and then he starts to walk away as the vehicle turns and runs over him.
And relative to 2 through 4, what are those showing?
Exhibit 2 appears to show show the Equinox as Mr. Bletcher is sucked under the vehicle. Exhibit 3 appears to be after Miss Burrell had driven over Mr. Bletcher and Mr. Hahn was out in the parking lot as she approached a second time. And then Exhibit 4 appears to be when she had returned in one of the other 4 times. One of the other 3 times that she returned to the scene.
Bobby, she did give him his credit card. It was found in the parking lot over where his body was, but past it.
And on Exhibit 1 in particular, the longer version, can you see an individual, Mr. Hahn, walking out of the extended stay and going over to that location?
Yes. And you can see that he's wearing the same red shorts that he's wearing when he speaks with police.
And does Exhibit 1 also show the number of times the defendant drove past after the initial incident?
It does. 1A. Yes.
Okay. And
B, thank you for the 100-bit cheer. Thank you.
what is the other video?
The other video is, so Exhibit 1 is just the 30-second video, or I didn't pay attention exactly how long, that just shows where she literally ran over Mr. Bletcher and then her driving out of the camera frame. And then 1A is the 3-minute, 30-second video that shows not only where she ran him over, but then also her return an additional 3 times.
And is one of them, I'll say, enhanced?
It's a closer, so Exhibit 1 is a closer zoomed in version of the video, and that's shortened.
Okay. And do those fairly inaccurately depict the surveillance that you observed in this case?
Yes.
Judge, we would offer 1, 1A, and 2 through 4.
Hey, what do you?
Yes.
Detective, you stated that the video was not collected by you, correct?
Yes, collected by Officer Materi.
Okay. And that was collected on April 3rd, 2026?
I believe it was actually not until April 4th when the videos were received.
Okay. And who did he talk to?
Who talked to?
The investigator talked to?
Investigator Materi?
Yeah, to obtain the video.
It would probably be in her report. The name, I think
I'm
it was
asking your knowledge.
somebody by the name of Simone or Simon, I believe.
Okay. And who was this person?
It's an RTD security representative.
Okay. And how was this video received?
It was received, I believe, in either email or in Axon. I don't remember. I'm sorry.
To you personally? Was it received via email to you personally?
No, I believe it was sent to Materi, Investigator Materi.
Okay. So after this investigator collected evidence, you reviewed it prior to this preliminary hearing?
Yes.
Okay. We would be objecting on lack of foundation and chain of custody on this case. This officer did not collect the video. The officer's a bit confused on who they requested it and how it was obtained.
Can you lay further foundation?
Yes, Your Honor. Detective Odell, did you direct anyone to go look for that footage?
I did.
Did you have any conversations with anyone, or did you just direct them to that?
I directed Investigator Materi to contact RTD and have her work on having them send us the video footage. And she had just told me as she was working with them, she called them numerous times throughout this evening, early morning, in order to try and have them send the footage. It was delayed because the footage had to compress, which was an extensive process. And then she finally received it. It was later on the 4th that they sent it to her.
Okay. And did you have a conversation with her about what she received?
A conversation, I'm sorry, with who?
Investigator Maturi,
About what?
about the video that she received.
So I think at that point in time, she didn't end up reviewing it herself. She ended up just submitting it, and then I ended up reviewing it before she did. And so, I mean, it was me that ended up reviewing it first.
Okay. And are you familiar with the area where this incident took place?
I am.
And does the video fairly and accurately show that area?
It does.
And does the video have a date and time stamp that correlates to the date and time of the offense?
It does.
Judge Weird, again, offer 1A.
Any objection?
We would maintain our objection.
Objections overruled. I will admit exhibits 1, 1A, and 2 through 4.
And Your Honor, may I approach to retrieve the exhibit?
Yes.
May I publish 1 at this time, Your Honor?
You may.
I can't say I never thought about running my ex over with my car, because that would be a lie. He's so tiny, though, the bumper probably go right over his head. I can't drive 55. I was taller than him. They're trying to get a video to work, I think. You know how that goes in a courtroom. They could be watching it without sound, too. I don't know, because I can't see. It looks like they are watching the video with no sound. I wish I could see her. Is she watching the video? Is she looking away? Is she looking down? Yeah, he was 5 foot. He was 5 foot even. I'm taller than 5 foot. I'm 5 foot 2 3/4. Which means I spent 19 years of marriage not being able to wear heels. That sucked. I love heels. I'm going to bump it forward just a tad.
markings that made them believe there was, and why they took swabs when they did the search warrant on the evening of the 3rd, morning of the 4th.
Going back to that evening, where was Mr. Bletcher taken?
He was taken to the Medical Center of Aurora. That's, now HCA Health One Hospital. It's recently renamed.
Did you receive medical records as part of your investigation?
I did.
And have you also visited Mr. Bletcher in the hospital?
Yes.
How many times?
Total of 3 different times.
Do you recall the approximate dates of that?
I went to speak with him on April 7th, again on April 9th, and then again on April 21st.
Where was he at that time?
He was in the intensive care unit, room number 55.
Was a serious bodily injury form filled out?
You might have mentioned that in the 90s, Bren. Just saying. Thanks. A lot.
By one of his doctors?
Yes.
And did you receive that as the investigator in this case?
Actually, it was uploaded by somebody else involved in the case, but I did see it, yes.
And was this something that would have been filled out at your direction?
That one was not filled out at my direction, but it was filled out by one of the officers, yes.
It's marked People's 5. You recognize what that is?
I do.
What is that?
It's the SBI form that's uploaded to the case.
And who does that pertain to?
It pertains to Antonio Bletcher.
And does that indicate a date that examination was done?
Yes, it says April 3rd.
Judge, we would offer 5 at this time.
The objection?
We would object to the form itself being hearsay, making medical statements for the truth of the matter would be our objection.
Be overruled. Yeah, Exhibit 5 is admitted.
And does that form indicate what forms of fractures Mr. Bletcher had sustained?
Yes. It indicates in the, let's see here, explanation free-form field below, it talks about multiple pelvic fractures, bilateral rib fractures, open fibula fracture, clavicle fracture, bilateral pneumothorax. Sorry, that's not a fracture. And then transverse process fractures to the C7, or is that might be either a C or L, I don't, maybe an L7, L3, and L4. And then a femur fracture.
And does that also indicate a substantial risk of death?
Yes.
Judge, I have no further questions. Your Honor, want to speak to it?
No one should hold on to that right now. Cross-examination?
Yes, please.
I'm already pre-annoyed at the lawyer, and I don't know why. She already annoyed me.
Good afternoon, Detective.
Good afternoon.
I just want to have first some clarifying points. You are the main detective in this case, correct?
Yes.
Okay. So when we had other investigators kind of fill in the blank, it was at your direction?
Correct.
Okay. And as part of being a detective, you were able to review all of the police reports that your officers had compiled in this case?
Correct, yes. There's
And-
a total of like 48 of them. I did not memorize them.
Yes, and all the body-worn camera that's been part of this case you've reviewed?
I have not reviewed all of it. We cannot review all of it. I would spend entire days reviewing body camera if I did that.
I think we have probably over 60 body-worn cameras in this case.
Yes.
Yeah. You would agree with me that you did not go on scene when the call for service came in, correct?
Correct. I was directed to go to the hospital, not to the jail, I'm sorry,
Okay.
to speak with Ms. Burrell.
What that means is other officers from your agency went to the scene to start investigating the case.
Correct.
Okay. You had mentioned that there was 2 initial officers that went in and saw Mr. Bletcher on the road, kind of by the curve, correct?
By the curb, yeah, on the north-hand side.
And then you stated that you could see from Officer Hughes' body-worn camera, it wasn't the right angle because of where they're stationed, but you can kind of see the injuries of Mr. Bletcher.
Correct. He arrived after our stint in Viera.
And Officer Hughes was kind of like the main guy in charge on scene, also telling people what to do and what to gather.
He took the primary officer role, yes.
Okay. We heard about an interview that was done with Ethan Hahn, right?
Ethan Hahn, yes, sorry.
He's the one that also called 911.
Yes,
Okay. In that interview that was conducted on scene, we learned that Ethan did not see how the altercation started between the 2 parties, correct?
correct. He responded to audible stimulus, which he then went outside to investigate.
So once he heard some yelling, he goes outside to see what's happening.
Correct.
Okay. That's when he tells us, I see this vehicle kind of driving off or maybe hitting someone and coming back. Like the story changed a little bit, like you stated.
Correct.
And as part of the investigation, Officer Hughes also spoke to Jason Hayden, who was also a neighbor of the extended stay, correct?
Correct.
Now, Jason Hayden told us that he just remembers a truck or an SUV honking their horn, but he didn't hear really any arguments, right?
I believe so, yes.
And when he went outside to take the trash, he saw Mr. Bletcher already laying by those rocks where he was found, right?
I believe so, yes.
But he didn't think anything had happened. He thought it was a potential overdose and didn't really pay attention to the man by the rocks.
That sounds correct.
He stated that's something that happens frequently in that area.
It is.
He did not see Mr. Bletcher be struck by a vehicle.
Correct.
Now, while officers are doing more of the on-scene investigation, you tell us that you get the call to go to the jail, correct?
Correct.
Before you went to the jail, Ms. Burrell was already interviewed by officers from your agency.
Correct.
Now, you told us a little bit about that interaction and what she said, but I want to clarify a couple of things. You stated that they were arguing about a debit card.
Correct.
Can you tell us a little bit more about that? What do you mean by that?
So she had said that she was going back to, the extended stay in order to return his card to him. And that, in the process of doing that, she was trying to hand the card out of the passenger window that was cracked because there had already been what she described as fussing, which I understood as arguing. And that the card got dropped and there was some additional exchange about the card. And I'm sorry, I might be blurring my 2 statements together because she also told me that. So I'm not sure exactly how much she told to the officers that went to the scene to go talk with her on Sable Boulevard. Anyways, at that point in time, he ended up coming over to the driver's side door, opening the door and began assaulting her there. She initially said that he slapped her. Mr. Bletcher slapped Ms. Burrell and then punched her, or she corrected to say that he punched her instead of slapping her.
And this is what she's telling the officers at her home, correct? Now, I want to talk to you about what she told you personally, so we're not conflicting statements.
Okay.
When she was talking to you, she gave you a little bit more of a background about the incidents with why she does not celebrate her birthday with Mr. Bletcher, correct?
Correct.
So when you spoke to her, it was April 3rd, right?
Correct.
And she told you my birthday's April 4th.
Correct.
She told you that she does not spend birthdays with Mr. Bletcher.
Objection, relevant.
And Judge, it goes towards what started the argument and how the debit card got started. So I'm given the full picture as far as the investigation as well.
I'll allow little leeway, but I was starting to try and connect what was the relevance as well.
Yes. So she told you that she does not like to spend her birthdays with him, and she has not spent the birthdays with him for the past 5 years, right?
Correct.
That is an issue for Mr. Bletcher when the birthday comes around.
Correct.
And she was trying to avoid seeing him on the birthday. So that's why she went to give him the debit card the day before her birthday.
I believe so, yes. Correct.
She also told you that he was upset at her because it was taking her a while to get to the extended stay to give the debit card back.
Correct.
Okay. Now, the hitting and the slapping, you testify that she said she was slapped in the face and that she was also hit in the face, correct?
She corrected her statement after she initially said that she was slapped. She
Okay.
corrected and said that she was actually punched. So she changed her statement.
And you saw the injuries to her face.
I did.
And either yourself or someone with you when you were interviewing her took photos of those injuries.
Correct.
And she also told you the officers previously also took injuries at my home.
You mean images?
Oh, sorry, took images of the injuries at my home.
Correct.
Okay. So you were able to see that on the left side of her face, the injuries were present.
Yes.
If I showed you that picture, would you be able to identify it?
Yes.
May I approach?
You may.
I'm giving you Defense Exhibit A. That is Ms. Burrell, correct?
Correct.
And we can see in the photo, the photo is depicting injuries on the left side of her face, correct?
Correct.
And that photo was taken when you were interviewing her at the jail.
Correct.
And we can see that the photo kind of goes to the top towards where her hairline is, correct?
Correct.
And that is a fair and accurate depiction of what Ms. Burrell looked like on April 3rd, 2026.
Yes.
Judge, at this time, I would move to admit Defense Exhibit A.
No objection.
Defense Exhibit A is admitted.
When we were talking about the slapping and the punching, she also told you that her braids were ripped off by Mr. Bletcher, correct?
Correct.
And when the car was processed in this case, you were able to see that a string of braids were in the vehicle.
Correct.
You told us on direct examination that she told you she never intended to kill anyone, correct?
Correct.
And that she was
Show us the pictures.
driving around to make sure that Mr. Bletcher was still moving and was okay, correct?
Correct.
Now, in the video that we saw, we see Mr. Bletcher hit the ground after the contact with the vehicle, right?
Yes.
But then we also are able to see, if we pay really good attention, how he moved himself from where the impact happened to where the officers found him, correct?
Correct.
So he himself was dragging, walking, crawling, something to the area of the rocks.
Correct.
Because the eyewitness that talked to the officers, he did not say that he physically helped Mr. Bletcher, right?
No, he said that he told him to roll down into the ditch.
Okay. Now, were you able to listen to the 911 call in this case?
If I did, it was a while ago. So,
If you don't remember something, just let me know.
okay.
On the 911 call, you can hear the reporting party kind of yelling at someone about what just happened, right?
I believe so. Yes, that sounds accurate.
And you can hear what appears to be a female voice being heard from that 911 call.
Yes, that sounds right as well.
Okay. Now, could you publish People's Exhibit 2?
It's up there. The judge.
I would be a spectacular child support attorney. Spectacular.
2 is right here.
People's Exhibit 2, they're screenshots of the video that we saw, correct?
Yes,
And they're screenshots to a very specific area of that parking lot, correct?
correct.
It's fair to say that in People's 2, 3, and 4, we are focusing to a very direct area of that parking lot.
Correct. In the location of occurrence.
And on People's 1 and 1A, we're again focusing in a very specific area of the parking lot, right?
Correct.
And we don't see footage of the vehicle in any other area of that extended stay.
Correct.
If I can have one moment, please.
Absolutely.
I could listen to Cindy
In
Lou's
People's
song
Exhibit 1,
forever. I love it.
we see the vehicle kind of making rounds around the parking lot a few times, correct?
Correct.
Part of that video, we see the vehicle making, actually, I'm going to show you that specific part.
Show the class. Show everybody. Bobby can't be a lawyer. He would just keep saying, Judge, just find him guilty. Judge, just find him guilty. Life in prison,
And I'm
Judge.
going to be showing you People's Exhibit 1 that's already been admitted. Yes, and it's doing the zoom in, zoom out on my computer. Okay, thank you.
I've never been guilty a day in my life. Never.
I'm going to be fast forwarding to minute mark 2:10 on the video. And I'm going to be playing that part. So in this part, we can see the vehicle kind of making a quick U-turn, correct?
Yes, I believe that was after she had approached from the east.
Correct.
And kind of slammed on her brakes right in front of him.
Correct. So right here, she's driving towards where I believe the body is. I can't really tell.
Yes.
Would you agree with that?
I would agree with that.
And she stops right before the body, correct?
Correct.
And then she stops the vehicle for a couple of seconds, right?
Yes.
And we're seeing it stop for a couple of seconds, and then she drives off.
Correct.
Every time she was coming back around, she was stopping that vehicle for at least a couple of seconds, correct?
I didn't time it, but I would say that's relatively accurate. That time when she approached much more slowly than the time that she approached moments before.
Sure. Yes. Yes, thank you. In this case, based on the evidence that you gathered, either through your officers or witnesses, it is certain that the impact with Mr. Bletcher was that initial impact, correct? There wasn't multiple impacts with the vehicle.
Correct.
Okay.
Multiple impacts with the vehicle. See,
You stated that you went to the hospital.
he hit her car, guys. She didn't hit him. He hit her car. Put him in jail.
To speak to Mr. Bletcher 3 times, correct?
Correct.
On April 7th, Mr. Bletcher did not want to make contact with law enforcement, correct?
That was when I called him and asked if he was willing to speak with law enforcement. When I went to the hospital, he explained that it was because he was fearful that it was somebody associated with Ms. Burrell, who she had told him she'd send to kill him.
Okay. So that was on April 7th?
Correct.
Okay. On April 9th, he was just medicated, so he was unconscious.
Correct.
And on April 21st is when you did your interview with him.
No, the majority of my interview was with him on the 7th, with Ms. Maturi, or investigative Maturi, present.
On April 21st is when you went back with the victim's advocate.
Correct.
And you were having him fill out the medical release forms. Okay,
Yes, and the domestic violence investigation form.
got it. Thank you for that.
See, now that's clearly a lie. She would never hire a hitman.
You stated on
She
direct
is the hitman.
examination that based on your familiarity with the area, you believe that the proximate distance that Mr. Bletcher was dragged was about 20 to 25 feet, correct?
Correct.
Okay. What do you mean by dragged?
So you can see it in the, briefly in the video where he gets hit by the car and is kind of being dragged while he's still upright. We call that dragging because his feet are already sucked under the car. So then the car actually ends up pulling him the rest of the way under and continues to drag him as it runs over him.
Okay. All right. So when we see the vehicle kind of going up and down, that would also be considered dragging.
Yes,
Okay.
because each time that one of the axles or part of the vehicle comes down to crush upon him, it's still moving forward.
Okay. Okay. When you reviewed or when you went to see the vehicle, that's when police had already taken custody of the vehicle and it was in the evidence bay.
Correct.
You said you personally did not see any apparent blood, correct?
Correct.
But it appears that CBI did swabs of what could be blood.
CSI did
CSI.
swabs on the night of the incident. Correct.
And those were sent out.
Yes.
To your knowledge, we have not received those back, correct?
Correct. The lab is telling us about 6-month analysis time right now.
Since April 3rd, did you go on scene to review the area yourself?
I have not.
So the photos that we have and the reports that we have from April 3rd are just what your team gathered?
Correct. Since the scene was processed by CSI and it was very thoroughly documented, I didn't think it was necessary.
Just one moment.
See, Bobby, no electric chair. No, no, no. We have to use something cheaper.
Okay. Thank you. Thank you, Judge. Those are my questions.
Any redirect?
Tanya.
Are the parties going to want to make a brief arguments?
Yes, please.
Yes, Your Honor. And people have no more witnesses.
Thank you. You may be.
Thank you.
Before we go into arguments and ruling, we're going to pass this for just a moment. Again, ma'am, you can just stay in your seat. If we want to go ahead and call 25 CR 3030 People versus Ravali. Ms. Prevey.
Sorry, Judge, what's that?
Do you want, I just called the Ravali case.
Yes.
Unless you want to stay longer.
Thank you. You're just pre-clearing dates. Thank you.
And Mercedes Prevey, on behalf of Mr. Ravalli, who does not appear, I would note that he was appearing by WebEx from Benton County earlier this afternoon. It looks like they brought him back to his room, and he's not able to return today for the hearing. The defense was ready to proceed, though.
And what are you asking the court to do today?
We're just asking the court to reset as soon as possible. Our understanding is that it looks like the court is not available the dates that we thought were available early June. So I think June 8th would be our best request based off of our availability and officer availability.
And for the people?
Air is too expensive, Bobby. No.
Your Honor, yes, I did see the defendant was on WebEx, and I don't believe this was a willful failure to appear on his part. It did look like he was sort of shooed away. Obviously, we made some efforts to get him back, but it doesn't sound like we could do so today. I did pre-clear dates with officers. I believe June 8th, while ultimately unfortunate as far as scheduling goes for the people, is the date that works best.
So the court will note for the record that we were set today at 1:30 for preliminary hearing. Mr. Ravalli did appear virtually from Benton County Correctional Facility as we tried to, the parties both announced ready to proceed, and we tried to take care of a few other matters first, at which point Mr. Ravalli was removed from the WebEx. The court is going to find that this is not a knowing or willful fail to appear on behalf of Mr. Ravalli, and therefore he has not waived his right to a preliminary hearing. I will find good cause to continue the preliminary hearing outside the initial 35 days and set this matter for preliminary hearing on June 8th at 1:30 in this Division 302. Counsel, one of the first things I was intending to do when we tried to call Mr. Ravalli's case, and it did appear we missed him by a couple of minutes, was to advise him pursuant to Rule 43. It's this court's preference that he be in person. Ms. Prevey, have you spoken to him about that?
I have, yes, and I was prepared to tell the court today that he's been fully advised of the rule and is consenting to appear by WebEx due to the long transportation from Benton County and being removed from that facility for a few days. He's requesting to appear virtually for the preliminary hearing.
Thank you. And does the prosecution have any objection to that?
Ultimately, it was approved last time, so at this point, we've not made an objection.
Okay. And I will stay consistent with Magistrate Brown's prior ruling and will authorize a virtual appearance via WebEx. Ask the prosecution to file a writ. Anything further from the defense we need to take on the record?
No, thank you.
Anything further from the people?
Nothing further. Thank you.
Thank you. And the court will recall 26 CR 811, People versus Burrell. Any witnesses on behalf of the defense?
No witnesses.
Any argument from the prosecution of People?
Judge, I don't know what the court's usual practice is. I guess my preference would be to reserve rebuttal. If the court doesn't allow that, then I'll make argument.
I will allow you to reserve on and move on.
Thank you.
Thank you, Judge.
The place I'm moving, the air conditioning and heat is, or at least the heat, is a mini split, and I don't know what that is. I don't know if that's electric or gas or what. It's a mini split.
We would be asking that the court not bind counts 1, 2, and 3. Our first argument, it's going to rely on People v. Huggins, 222 Pacific 3rd, 977, Colorado case 2009. Understanding that at preliminary hearing, hearsay is admissible for most of the hearing, which is what we heard today. The preliminary hearing itself cannot rely solely on hearsay evidence, and I know that this court knows that standard in the case. In this case, I have objected a few times as to hearsay, just to kind of bring the court's attention to the issues that what the officer was relying was solely on hearsay and that no other evidence was presented at preliminary hearing to supplement that, to show enough credible supporting evidence to kind of get over the hearsay part. First, we hear from an eyewitness. Clearly, that is hearsay. It's a statement that was made out of court for the truth of the matter asserted. It was made to an officer. It was not made to the detective, as the detective never went to the scene. So we have multiple layers of hearsay. And they're relying on that hearsay to show potentially the mental state of Ms. Burrell. They're also relying on that hearsay to potentially show the lack of injuries that Ms. Burrell herself obtained prior to the contact with Mr. Bletcher. And then they're relying on an SBI form. The SBI form told the court some of the fractures that Mr. Bletcher suffered due to the contact with this vehicle, but we did not hear anything from the detective himself that he, in his investigation, spoke directly with the nurses, with the doctors to verify this information. We have no non-hearsay evidence to show serious bodily injury in this case. The list of fractures that were mentioned are being introduced for that truth of the matter, and that's why I objected. But nothing else was presented to support that. That would be also credible evidence. Typically, we could have a detective speak of the SBI form and then speak of his own observations that he made of an alleged victim. And in this case, we did not hear that. We know that this detective did not go on scene to see the initial injuries of this Mr. Bletcher. We know that he never, during the course of the investigation, went to the scene to see any of the damages. And even when he went to the hospital, he told us that he was able to interview Mr. Bletcher and then subsequently go and get release assigned, but again, no explanation of potential injuries. So that would be our first argument, specifically as to the issue of serious bodily injury, which is charged in count 1 and 2. Additionally, I would like to put on the record the sense of right now, Ms. Burrell is being charged with obviously very serious charges, with count 1 being a class 3 felony. I want to make sure in rebuttal that the people are able to tie the evidence that was presented today by their singular witness and show us and show this court what they presented as far as mental state. It is important, and they have to present evidence of mental state in this case. And if we look at the 3 charges that we have,
They don't have to present evidence of anything. Don't tell them how to do their case. Do they have to present evidence of mental state?
each of those charges carry a different mental state. We have count 3 that carries Ms. Burrell under circumstances manifesting extreme indifference to the value of human life, unlawfully, feloniously, and knowingly engage in conduct which created a grave risk of death to another, therefore causing serious bodily injury. We have assault 2 in the second degree, that is the intentional, with intent to cause bodily injury to another, cause the bodily injury. And then we have the reckless mens rea of the attempted manslaughter. I think the evidence needs to point directly to which of the statements by this investigator, by this detective, goes towards that. What was the reckless act? What was the intentional act? And what was
running him over with her car is the act. She hit him with her car because she thinks hitting someone with a car is the same as hitting someone with your hand.
Was the manifesting extreme indifference? Because the act itself is the same. They're saying that she hit Mr. Bletcher with her vehicle. That is the act that they're charging, and that serious bodily injury happened. I believe that there has been no evidence to show that Ms. Burrell concurrently, simultaneously was creating all these different mental states. And therefore, we are asking that the court not bind over those counts.
Bread chili is delicious.
Thank
You
you.
would really like it
Rebecca.
with cornbread.
Thank you. What counsel is suggesting is something that Huggins does not hold. She is suggesting that each element must be supported by non-hearsay evidence, and that's not what Huggins says. Huggins says that we conclude, following Van Meerven, that the prosecution satisfies the minimum required for non-hearsay if, one, it presents some competent non-hearsay addressing essential elements of the offense, and two, presents hearsay testimony through a witness who is connected to the offense or its investigation and is not merely reading from a report. In another section, it says, unlike the witness in Maestas, who was only peripherally involved in the investigation, the witness in Van Meerven was the investigating officer, someone who had knowledge and information about the many aspects of the alleged crime. In this case, Judge, we have the date, time, location, and identification coming in non-hearsay testimony, as well as the non-hearsay testimony. It's not a hearsay testimony, the non-hearsay exhibit of the video. So the people have more than met their burden as far as non-hearsay elements in this case. With regard to the argument that the people, or the question, if the people can prove all three of these mental states, as the court is aware, Colorado has a hierarchy of mental states, and intent is the highest mental state. Starting with count 2, which is the assault in the second degree, that is the one that has the intent. And the defendant described to Detective Odell that she intentionally hit the victim with her car. She said the same thing to the officers who came to the door, that she intentionally hit him with a car. So her act, her mental state was intentional. Below that in the hierarchy is knowingly. And she indicated, again, by admitting an intentional act, she admitted that she knowingly hit him with her vehicle. And with regard to the reckless state, this is, again, a person knowing a risk and disregarding that risk. The court can certainly take notice of the fact that the defendant knew she hit knew she hit Mr. Bletcher with her car.
We all knew she hit Mr. Butcher with her car. Maybe it's better that way. Because now you're not just sitting there in Australia thinking, oh, I wish I had another piece of that cornbread. It was so good. You don't know if it's good or not. It could be horrible. So you can be fine in Australia. But it's so good. Cornbread?
And that could result in his death. A normal person of average intelligence would know that if you run over a person, that could cause their death. And that is the reckless state, that she disregarded that possible outcome from her conduct. So based on that, Judge, we believe that we've met the burden, and I don't know if the court has additional questions.
Do not. Oh. As the parties are aware, the purpose of the preliminary hearing is to see if the prosecution can present evidence sufficient to induce a person of ordinary prudence and caution to entertain a reasonable belief that a crime was committed and it was the defendant that committed the crime. The evidence presented must be viewed in the light most favorable to the prosecution, and if there is any conflicting testimony, then the court must draw any inferences in favor of the prosecution. People v. Williams, 628 P. 2nd, 1101. That is the Colorado Supreme Court, 1981. The court also can consider evidence that might not be admissible at trial, such as hearsay, and that type of evidence may properly, comprise the bulk of the evidence at the preliminary hearing. And I'll cite two People v. Jensen at 765 P. 2nd, 1028, Colorado Supreme Court, 1988. Each of the parties referenced People v. Huggins, and Huggins does state that the prosecution sets where the bulk of the evidence may be comprised of hearsay. The prosecution satisfies its minimum requirements for use of non-hearsay at a preliminary hearing if they present some competent non-hearsay evidence that addresses an essential element of the offense and presents the hearsay evidence through a witness who is connected to the offense or the investigation. And further, that the defendant's statements admitted through a detective are sufficient non-hearsay, even if those statements are contradicted. That is People v. Horn, 772 P. 2nd, 108, Colorado Supreme Court, 1989. Parties are also aware affirmative defenses are not at issue in a preliminary hearing. And I will note that I have considered the testimony of the detective, the arguments of the party, and considering the evidence and testimony presented, as well as the reasonable inferences therefrom, in the light most favorable to the prosecution. I will find probable cause. I will note for the record that Detective Odell was the sole witness. He testified that law enforcement was dispatched or responded to the scene following a 911 call of the reporting party indicating that a man had been run over in a parking lot. That was on 13941 East Harvard in Aurora, Colorado, Arapahoe County. Officers responded and observed, the victim, Antonio Pletcher. He was laying on the ground and appeared to have visible and severe injuries. I will also note for the record that at a preliminary hearing, officers can rely on the fellow officer rule and additional information that they have received. This detective testified that he was the lead detective, had reviewed, and this testimony was based in part on his reviewing of other officers' investigations, statements they obtained, and information. Responding officers spoke with a witness, Mr. Ethan Hahn, who indicated he lived in the area. He came out to a balcony and he had heard some shouting or people arguing. He then went over or walked over to the scene. He saw the victim laying on the ground. He had previously heard what he believed were a male and a female who had been arguing or exchanging words. He was inconsistent, although he did indicate at one point that he saw the victim get hit by a car and that there was a female driver of the car. There was also officers, as well as personally, this detective did interview Miss Burrell. In those interviews and statements by the defendant pursuant to the rules of evidence are non-hearsay. Miss Burrell told law enforcement that she'd gone to the extended stay. She was bringing back the victim's, Mr. Bletcher's, credit card or debit card. She was in the car. They argued. Mr. Bletcher did come over to the driver's side of the car where she had the window rolled down. Ultimately, he opened the door and struck her repeatedly. And at that time, she hit him with the car. She also told officers that, let me rephrase, did appear that her statement to Mr. Hahn was that she would have hit him again if he attempted to get up. She repeatedly drove. There is video surveillance that shows the vehicle hit what has later been identified as Mr. Bletcher as the victim with the car. This is consistent with Ms. Burrell's statement that she hit him. He was dragged on the floor, on the ground, and across the parking lot. It's a question what the distance is. Mr. Pletcher was ultimately taken to, I believe, Medical Center Aurora, and was treated. He was held in the ICU for some time. Officers obtained information.
I'm guessing maybe self-defense, that defense might come out at trial, maybe? Sounds like self-defense to me.
A release of information, and then to demonstrate that a doctor had filled out, Dr. Hill, a serious bodily injury form, noting that the injuries received included a substantial risk of death, substantial risk of serious permanent disfigurement, and numerous breaks and fractures. I will start with count 2, second-degree assault, serious bodily injury. A person, the elements of that offense is when an individual, and Ms. Burrell has been identified on the record, and as well as identified as the individual who made as the defendant and made the statements admitting to driving the car and hitting Mr. Bletcher with her car. Second-degree assault is with the intent to cause bodily injury, caused serious bodily injury to another. Court is allowed to make reasonable inferences and look at the totality of the circumstances of the evidence presented to determine if there is sufficient evidence of probable cause related to intent. And intent is defined as your conscious objective to cause a specific result described by statute defining the offense. It's immaterial whether the result actually occurred. In this case, the element is intent to cause bodily injury. I think that it is reasonable in common understanding that if you intentionally or you try and hit somebody with your car, that you are going to cause bodily injury, which simply can mean pain to another. And then in this case, actually caused serious bodily injury as supported by the serious bodily injury form submitted into evidence as well as the testimony of Detective O'Neill. Furthermore, as the district attorney noted, we do have a hierarchy if there is a specific intent that necessarily shows that the individual acted knowingly and or recklessly, as those are lesser mens reas. First degree assault and extreme indifference is that a person acted knowingly, meaning they were consciously aware of their actions or aware that their actions were practically certain to cause a result, and under circumstances manifesting an extreme indifference to the value of human life, engaged in conduct which created a grave risk of death to another person and caused serious bodily injury to that person. I've already addressed the serious bodily injury previously in this ruling. I believe that by consciously or knowingly hitting another individual with a car, that there is probable cause that Ms. Burrell acted and engaged in conduct which created grave risk of death to another person and manifesting extreme indifference to the value of that person's life. Again, as to attempted manslaughter, the mens rea, and that is recklessly, and that is consciously disregarding a substantial and unjustified risk. At this point, the testimony and the evidence presented is that Ms. Burrell intentionally, knowingly, drove her car and hit this other individual. Clearly, that would include disregarding a substantial risk that she could have killed Mr. Bletcher. And so recklessly caused, and my apology, it is attempted manslaughter. So it does not have to clearly be a completed offense, but that she engaged in conduct constituting a substantial step and towards causing the death of another person. The court does find probable cause and will bind over all 3 counts for an arraignment. Is there any further record or argument that the defense would like to make at this time?
No further record or argument based on the court's ruling.
And from the prosecution?
No, Your Honor.
Okay.
And this is where the court can offer June 8th or June 15th at 8:30 a.m. in Division 402.
We can accept June 15th. We had also reserved the issue of bond.
Sorry, can I have just one more?
Yes. And what was that date?
June 15th, but I think
I didn't catch the time.
Oh,
okay.
Thank you.
Yeah.
Yes.
Thank you, Judge. The people can't accept the 15th.
Okay. And is the prosecution prepared to go forward? Do you have VRA to address bond on this date?
Yes, Your Honor.
And for the defense, you can address bond. Can you start with, is there any change in circumstances or anything that is different other than what was argued previously?
Yes. As far as change in circumstances, it looks like bond was argued when she came in before the filing of charges. When she came in with an attempted first-degree murder charge based on the affidavit, and that's the bond that was argued. When filing of charges happened, bond was not re-argued, but rather reserved, and we wanted to wait to preliminary hearing to bring up the issue of bond. So I would note the court did a very detailed explanation of the evidence that was presented. Attempted first-degree murder would be a Class 2 felony. Obviously, we are at a lower actual charges that just been bound over, including Class 3 felony and Class 4 felony. Ms. Burrell is just asking for a slight modification. It's $75,000 right now, cash or surety. Ms. Burrell, and this was told to the court previously, that she does have 3 kids. However, one of her children just turned 12 yesterday, and she was obviously in custody. Her other child, who's present in the courtroom, is graduating high school. This was not previously argued. She would like to be present for that milestone. And her oldest son is currently kind of taking up the role of male figure in the household, who is 22 years old. She's relying not only on her children, her brother's present in court as well. We are putting a $75,000 cash or surety, but I think we did not take into consideration any of the positives that should give her a downward deviation from any type of bond guidelines. We did not take into consideration her lack of criminal history. Pretrial services put her at -3, but we have not received any certified convictions relating to Ms. Burrell, and they specifically stated that they are unable to confirm whether or not the charges that were noted ended in a conviction. Based on my conversations, I can tell the court that they didn't, she does not have any prior felony convictions, and I think we need to associate the positives and start deducting on that cash amount. The court did not take into consideration all of the family support that she has, not only through her children and her brother, but through her mother. They're all are people that are wanting to help her, and they are wanting to gather the money to be able to get her out of custody. Another issue that we ran through today, and then I spoke to the people about this, the vehicle in question was taken into evidence and then released into an impound. We are going to be filing a motion to release the vehicle altogether to her brother, but it's been accumulating $40 a day since the day of the arrest. That is a fee that they're going to have to pay to get the vehicle out of the impound. So that is an added monetary condition that if they want to bond Ms. Burrell out of custody, not only do they have to pay a very high bond, but now they also have to pay a very high bill to get her vehicle out. She is employed. She has support for her family. She has no history of failures to appear. This is a case, after listening to preliminary hearing, that it's going to rely on the evidence presented of self-defense, presented based on the injuries that she suffered herself during this incident. And I think that does diminish a little bit as far as the conduct that is alleged against the reason for that conduct. So we are asking that the court modify bond. we'll be asking to set it nothing higher, the $50,000 cash or surety, but absolutely modification of bond is what we're relying on.
And for the people?
Your Honor, people are asking the court to maintain bond where it is. There is a VRI objection to reduction in the bond. I would note that first degree assault, the scheduled amount is $75,000 cash or surety. One of the things the court has to look at is the substantial weight and evidence that in this case going to trial.
Nobody in chat has given me my opinion on this carpet yet. Just wondering why not. Do I hate it or like it?
In this case, there is substantial evidence that the defendant committed these crimes, as well as the fact the injuries here are catastrophic, and everyone here is fortunate this was not actually a homicide. I would also note that the defendant left the scene, did not call 911 herself. So I think those things more than offset the things that counsel has brought up here as far as that. And I think most importantly is this case carries a mandatory minimum of 10 to 32 years on count 1 and 5 to 16 years on count 2. So based on that, there's a substantial likelihood of the defendant's flight and believe that schedule in this case would be appropriate.
Thank you. The court, having reviewed its court file as well as hearing the preliminary hearing today and reviewing the pretrial bond report as well as the arguments of counsel, I do believe it is appropriate for us to argue or to address bond today. Notice was given to the prosecution and they are compliant with BRA. Will note, as argued by the defense, that there is a reduction in the charge. There was originally a probable cause finding as it related to a class 2 felony of attempted murder in the first degree. Given that I was the magistrate that originally set the bond, I can make the record that in fact, looking at there was consideration in the fact that Ms. Burrell does not have any criminal history. That she had significant ties to the community, and the defense did argue that she had 3 children in this community that she is responsible for. I thought it an interesting issue to say that to a class 2 felony that of attempted murder bond guideline was $75,000. Because we don't specifically have a guideline as it relates to the inchoate or attempts. But typically, if there is a violence enhancer, that does tend to be higher than the $75,000 guideline amount. I'll note for the record, for a
Oh my
first
God. Is she gonna up the bond? Is she gonna make it higher?
degree assault, which is one of the charges that we just bound over for, that the guideline is $75,000. And the information is also that Mr. Pletcher did receive catastrophic and severe injuries that constituted a significant and severe risk of death, as well as multiple fractures all over his body. Given the objection by the district attorney as well as the victim in this case, and based on the evidence I heard today, the court will decline to reduce the bond at this point. I do believe that bond guidelines at $75,000, given the nature of the allegations, the evidence presented, likelihood of conviction, that $75,000 is a reasonable bond.
I agree, Judge. So there you go, guys. Even in self-defense, if you run somebody over with your car, you better have $75,000 in your pocket, which she doesn't.
Yep, great.
Is the record started?
Yes.
All right, today is May 11th, 2026. This is the Douglas County Court and District Court. My name is Stephen Sletta, presiding over 4 cases. They are 26 CR 213, 26 M 278, 26 M 590, 23 CR 1224. All of them are people versus Russell Bauer. Pardon me, Mr. Bauer. And district attorneys present?
Yes, Your Honor. Chase Elseth and Anastasia Gann for the people.
And Alana Smirin with the Public Defender's Office on behalf of Mr. Bauer, who's present in person.
Please accept my apologies for not being there in person. Just a matter of a family timing problem. And I apologize. Mr. Bauer's entitled to have a judge present, and I just couldn't do it quite well today. Today on the 26 CR 213 case, we're set for arraignment. The 26M cases are trailing. The 23 CR 1224 case has recently been assigned to myself to preside. It's a probation revocation from a few years ago, and it was recently assigned to myself about a week and a half ago, 2 weeks ago. All of the cases are really set for a status conference. I'll ask the district attorney, is there any disposition of the cases today?
No, Your Honor, and I think actually it might make more sense if Ms. Smirin kind of states the request and where we're at this point.
Always ask the prosecutor first.
That's fair.
Defense?
Your Honor, we are not at a disposition. I can let the court know my concern with the proposed disposition that was sent by the people. The people are aware there is an out-of-state case in South Dakota against Mr. Bauer, which does prevent him from being placed in the halfway house.
Kristen, I know you're not here. You're on replay crew, so you're going to see this later, but Sodak, South Dakota. Guess where his case is in South Dakota? Guess. Minnehaha.
Which was the offer made by the people. So I can let the court know with regards to 26 CR 213, 26M 590, and 26M 278, we would be requesting to enter a not guilty plea and set these matters for a jury trial. And then we have put the people on notice, and we are asking to address bond on the probation revocation matter 23 CR 1224.
It was my understanding that a misdemeanor case would be dismissed on the filing of the felony case. Am I mistaken on that, counsel?
You are correct, Your Honor, and I think that is 26M589, and my understanding is that has been dismissed already.
So we're left with the two other misdemeanors.
Yes.
Correct.
Okay, well, the court has received not guilty pleas as to each case and counts. Do you want me to go through the counts or just accept the general not guilty plea, counsel?
Your Honor, I met with Mr. Bauer yesterday to advise as to the sentencing ranges as to the charges. So we would waive further reading and advisement on that.
We'll accept not guilty plea as to all charges on all three counts or all three cases. And what's the district attorney's preference? Do you want to try the misdemeanors first or the felony first?
Judge, I don't know. In all candor to the court, I anticipate filing a motion for joinder in certainly the misdemeanors. I understand we could set them both separate today, depending on how the court would rule in that potential motion coming forward. I want to look at some of the case law and the facts. It's possible I will file a motion to join the felony as well. I think maybe it makes sense to set the misdemeanors as they are VRA. And then the felony, obviously the same speedy trial will be for the same, but I think since the misdemeanors are VRA, maybe we do those first.
How much time do you anticipate to do what you want to do, counsel?
Judge, I apologize. As far as filing a motion or for how much time we would need for trial?
Filing a motion.
I don't know what this court's standard practice is or what the court typically does. I think if I could have about 30 days to file motions, I'm guessing Ms. Smirin will want to file any motions that she might have as well.
We're only talking about whether you're going to consolidate, whether you want to consolidate or not.
Oh, just that particular motion?
Yes.
Your Honor, I'm out next week, but I don't anticipate it would take a long time to file, so I think I could do it within 2 weeks.
Are you working the 29th of May?
I am, Your Honor.
defense counsel available the 29th of May?
Yes, Your Honor.
So my preference is to continue trial setting until May 29th. We'll deal with the motions to consolidate, and that way we're not going to waste time. The court will enter the not guilty pleas today, so the defendant's speedy trial starts.
That makes sense.
That works for me. As the court mentioned, as long as the not guilty plea is entered as of today, we have no objection.
And the court will make orders as to trial procedure once I know whether we have one trial or two trials or three trials.
That works.
So what time do we have available for the court on May 29th? Just need an empty courtroom, I guess.
Yeah, Your Honor, the staff here has told me 1:30 works for them. I don't know if that works for the court.
It's fine. Is it, and since you're going to relay that, since their microphones aren't working, in the same courtroom we are today?
Yes, in the same courtroom, yes. They are indicating yes, Your Honor.
Matters are then in the three cases we've talked about, 26 CR 213, 26 M 278, 26 M 590. Those matters be continued over for trial setting 1:30 on May 29th.
And just so I make sure I comply with the court's order, does the court need the motion in advance of that date to be able to review it? Is there a filing deadline that the court had that I missed?
I think if you file it by that morning, I ought to be able to review it.
Sounds like a plan. Thank you, Your Honor.
So then we move on to, and I believe 26 CR 213 is a no bond hold.
Your Honor, the only case that I'm aware of that has a no bond hold is the 2023 probation revocation matter.
That's correct. I had a $20,000 cash on the 26 CR 213. Thank you.
And I have bond argument whenever the court is ready.
So I have a procedural matter to discuss with you briefly. It says on the status conference on April 20th, held by Judge Stewart, that Judge Stewart denied a bond modification.
That is correct, Your Honor. I did receive some additional information out of the case in South Dakota that I informed the district attorney's office on. So I do think there's a change in circumstances that the court can consider with regards to the setting of bond.
And you got a different judge.
That too, but I did have the information from the public defender's office in South Dakota, and I did not receive it until last week.
Any objection by the DA to the court reconsidering bond?
Judge, I'll tell the court I'm on notice and have a VRA position. I am objecting to any modification of bond. To be frank with the court, my first argument to the court would have been I don't know what the change in circumstance, if there is an adequate change in circumstance. So I suppose I object, but I'm prepared to address it and VRA compliant to address it.
So we'll ask defense to provide to us an argument with regard to bond modification.
Thank you, Your Honor. So I did let the people know, and I think they are aware as well, there's an underlying new offense out of South Dakota that predates the new law violations here in Colorado. And I was able to speak via email and over the phone starting last week with Mr. Bowers, public defender in South Dakota. And I've been advised that that matter is currently set for a jury trial to begin the last week of June. I am concerned that he will not be able to be present for his trial in South Dakota if this no bond hold remains. And I can also let the court know Mr. Bauer's father is present in the courtroom. His name is Brett Bauer, and he is Mr. Russell Bauer's legal guardian, which I also did not receive the formal documentation supporting that until last Friday, which I also provided to the district attorney's office regarding Mr. Bauer's kind of living situation and circumstances. He does have his parents as his power of attorney and legal guardian due to the mental health considerations surrounding these cases, which the district attorney's office are very much aware of in these cases. And so I think it's something for the court to consider. I would also let the court know, as I mentioned earlier, we're not in the position to resolve these cases, but the offer that had been extended was a community corrections sentence, which Mr. Bauer will never be placed and accepted in community corrections while there is a pending out-of-state case. And so that case in South Dakota has kind of forced, in some ways, a pause here in that we can't really progress his cases in the way that the people want while he has this pending case open and set for jury trial coming up at the end of next month. We're not asking for a particular amount for bond, but we are asking for the court to consider the setting of a cash or a surety bond to allow Mr. Bauer to return to South Dakota to deal with his upcoming trial that obviously does have a sooner speedy trial deadline than the cases that we're dealing with here.
Thank you. Anything else?
I don't believe so unless the court has questions for me surrounding that change in circumstances.
In the probation revocation complaint, the allegations out of the South Dakota court, Minnehaha County, involve a class 5 felony called a terrorist threat and a count 2 stalking or following a class 1 misdemeanor. Do you know of any other charges or modifications?
I don't, Your Honor. Mr. Helseth, I know, spoke with the district attorney prosecuting that case, and I think we're aware that conversations are being had between the parties regarding a potential resolution, but I am only aware of those 2 charges that the court has just recited.
District attorney's reply.
Thank you, Your Honor. First of all, on that issue, I do agree that those are the 2 charges that I'm aware of in South Dakota. Your Honor, people object to modifying bond. I think this is now the 3rd time the court has heard bond in this particular case, Mr. Bauer. And it was on 3 different judges. Judge Wahola saw it at first, so it's picked up. Judge Stewart, now, Your Honor. And Your Honor, I think the people's position has been consistent, and I think I've already made my record. I don't know that there's a sufficient change in circumstances, but regardless, there's a number of concerns here that people have, not only for community safety, but also Mr. Bauer's ability to comply with court orders and be present here. I'll start with the most recent pretrial report we have in this case, Your Honor, that is filed, I think, back in March. It indicates that Mr. Bauer is a 5 out of 6 on criminal activity, so a high criminal activity score, and a 4 out of 6, a high failure to appear score. So I am concerned not only that he's high risk, I also note that the court knows about this South Dakota case. I'm concerned about that as well. I think the allegations in that case are that Mr. Bauer had called and made threats to bring a weapon and cause harm at a church in South Dakota when it was busy. I think that's incredibly concerning for community safety. The court also then is aware of the number of new cases here. There are 2 cases with allegations of violation of protection order, another pending felony with regards the 26 CR matter, that is an attempt to influence charge. I'm very concerned about some of the community safety concerns with Mr. Bauer, and I think a no bond hold is not only authorized, but appropriate. I'd also note for the court that the people had to extradite Mr. Bauer from South Dakota, and I think the indication is that he is a resident there. That's what the pretrial report says. I'm concerned about his ability, if he were to be granted bond, if were to travel there. I'm concerned about this court's ability to bring him back to Colorado and answer for the charges in 4 pending cases in Colorado, and that we would have to extradite yet again. And so I think that is something the court should consider. I recognize he's got trial there, and that happens sometimes, I think, when multiple jurisdictions, there's cases in multiple jurisdictions, and I don't think that means that we must just defer to South Dakota. So I am concerned about that as well. Your Honor, I will also let the court know that 23 CR 1224 is a VRA case. The victim did not wish to be present today. She's objecting to lowering bond. She did want me to read a statement to the court. She said that when she knows that Mr. Bauer is not in jail, she fears for the life of herself and her family. He has repeatedly shown that he's a threat to community. He has continued to harass herself and her family for the past 15 years, and she wants it to stop. She does not want anyone to get hurt with Mr. Bauer out on the streets. She just has to take a lot of time out of work and away from her personal life to deal with the harassment, court proceedings, reporting, and this has caused so much stress for her and her family, and she'd like it to end. So given all of that, Your Honor, I am objecting and asking the court keep bond at a no bond hold as set.
Does the district attorney know what bond amount was set in South Dakota?
I did at one point, Your Honor. Give me one moment. I might.
Your Honor, it's defense's understanding that the bond in South Dakota is set at $25,000.
That sounds right. I think that is correct.
Does the defense know whether Mr. Bauer has posted that bond?
It is my understanding that Mr. Bauer has posted that bond, yes.
Okay, court sets this bond at $75,000 cash. Matter will be continued until May 29th at 1:30. In addition to the bond of $75,000 cash, the court imposes the same conditions that existed to bond on 26 CR 213.
Understood. Thank you. Nothing further from defense at this time.
We will see you the 29th. Thank you. Anything from the prosecution?
No, Your Honor. Thank you.
Defendants remanded into the custody of the sheriff pending bond. Do you all need anything more from me?
I don't believe so, Your Honor.
No, thank you.
I'm going to leave this WebEx meeting and I'll see you all in person in 2.5 weeks. Thank you.
Thank you.
No, you won't. There's no way he's coming. There's no way he's going to be there. None. Zero.
See, 26 CR 1539. Trailing misdemeanor.
And Your Honor, I would like to make a record first. So the 2026 M2338 is a duplicated filing that doesn't include a kidnapping. And then the 26 CR 1539 doesn't include the same charges, but has a kidnapping charge attached. I can let the court know that in reviewing the case, I did run across an issue looking at the kidnapping charge, specifically proving that there was greater harm for the location moved to. Specifically, the allegations are that the victim was moved from the inside of a closet to the outside of a closet, and as well as so there's sort of an argument here. First of all, that there wasn't moved to another location. And then there's also an issue regarding
charges kidnapping because the victim was moved from inside of a closet to outside of a closet.
a greater harm. It does appear that there's exits from the room outside of the closet. So it would be taking from enclosed space to an open space. I did VRA with dismissal of the kidnapping. It is the intent to dismiss the kidnapping and send this case to county. However, there is the duplicated filing, so I do think that I can dismiss 2026 CR 1539 in whole and allow 26 M 2338 to go to county because it has the same charges without the kidnapping.
All right, so you are moving to dismiss 26 CR 1539 at this time?
That is correct, Your Honor.
Mr. Foley? Objection. Okay, then I will grant that request. That case will be sealed, but I understand we have the other misdemeanor case still pending.
And Your Honor, I did want to bring up one issue because I would have filed a motion to dismiss in advance of this hearing here today, but the victim did want a modification to the protection order and did give me some reasoning on why the modification was necessary. So The victim is asking that the no contact provision and the vacate the home provision be removed from the protection order. And the reason is there is a medical procedure where she will have to be put under, which actually occurs tomorrow. It's been a pre-scheduled surgery. They moved here from a different state. There's not a whole lot of support that she has or people that she knows that can transport her to and from the hospital for the purpose of surgery. So she would like to have the vacate the home as well as the no contact provision removed. And based on the necessity, the people would have no objection to that modification of the protection order.
All right, so I wasn't going to address that today once you said you were dismissing the felony, but because of the short time frame, I think we'll try and address that. Mr. Foley, is there any objection to that? No. All right. Then here's what I will do. I will, in the misdemeanor case, since the other one's being dismissed, modify the protection order to remove the vacate the home and the no contact provisions. The protection order itself, sir, will still remain in place, so you cannot harass, retaliate against. All of that language is still contained in there. Because I'm modifying this, sir, I need you to not leave. I need you to stick around until we're able to modify that, print it off, and have you sign it. Once you sign it, you are able to go, okay? But it won't go into effect until it's signed. We have a date for that misdemeanor case yet and division?
It'll be next Friday, May 22nd at 8:30, in Division D as in David Foley.
I think that's what it was named after, yeah.
May 22nd at 8:30. Mr. Shelton, remember, don't leave until you've signed that protection order, okay?
Yes, Your Honor.
All right, thank you. All right, we're going to call Miss Santiago. I think this is take 4 or 5 at this point, but it looks like we're ready. 25 CR 324 and 25 CR 2869. The 25 CR 2869 is set for arraignment today, and the other case is trailing. Where are we at, guys?
I can let the court know that people have a record to make as far as the arraignment case, and we do have an agreement for the trailing revocation.
All right, well, I think that previews what the record might be, but Mr. Getz, go ahead.
Yes. So, Your Honor, contact with Mr. Berry, who appears, Mr. Bobby Berry, who is the victim in this case. The last contact that our offices had with him was August 12th of 2025, it looks like. His text message stated, "This all needs to stop. I did not start this. I never wanted this. Yes, I want contact with her. All of this is a waste of taxpayer money and caused a nice, sweet woman to spend several days in jail, plus cost me money for bail. What a scam this has been. Needs to stop now. Squash it." Now, I did try to make contact. I did ask for an opportunity to set this over as this case had been pending in warrant status. I can let the court know that I have been unable to make contact with Mr. Berry. I would note that Mr. Berry is an essential witness if I was to go forward on this case in terms of identifying Ms. Santiago. So with this having a low likelihood of success, if it were to go to trial, the people would be moving to dismiss 25 CR 2869 at this time.
And since this is a DV case, I think the magic words are that you would not.
I could not meet my prima facie case, Your Honor.
There we go. All right. I assume there's no objection to that? All right, that is granted. 25 CR 2869 will be dismissed and sealed. That leaves us with 25 CR 324. I see the main allegation was the new case, but there are still technicals. So, Mr. Donnelly, what's the agreement there?
We do have an agreement for probation to be revoked and closed with a jail sentence of 124 days with 124 days credit for time served.
Sherry, thank you for the flower with the 30 joules. I appreciate it. Monica, thank you so much for the cheers. I appreciate it. Thank you.
Ms. Santiago would be admitting violation of condition 8, participating in successfully completing treatment.
All right, looks like this was a DM1, so we can do that. All right, Ms. Santiago, I'm tired of saying it and you're tired of listening to me say it, but we're going to talk about this probation complaint again because I need to do this on each case. You understand that you're here on allegations that you violated the terms and conditions of your probation, but those are just allegations, correct?
Yeah, but Judge, the victim said it's a waste of taxpayers' money. Weren't you listening?
Yes, I understand that.
Okay. You're entitled to a hearing on those allegations where it would be the DA's burden to prove that you're in violation of the terms and conditions of your probation. And if they failed to prove that, then I would not revoke your probation at all. Do you understand that?
I understand that as well.
Okay. What I'm being told is that you want to waive your right to have that hearing and instead admit violation in exchange for the agreement that your attorney just put on the record. Is that correct?
I do.
Okay. And I guess I didn't confirm. Is that the people's agreement, the 124 with credit 124?
It is, Your Honor.
Okay. All right. And Ms. Santiago, your attorney tells me you can admit to condition number 8, which says that you were ordered to complete a substance abuse evaluation and comply with recommended treatment, and that you have not completed that evaluation. Is that accurate?
Yeah, I didn't do any part of it.
Okay. And do you agree that that's a violation of the terms and conditions of your probation?
Undoubtedly.
All right. Then I'm going to accept the admission, find it's knowing, voluntary, and intelligent, and that Ms. Santiago is represented by competent counsel. I intend to accept the agreement, but people, any sentencing argument?
No, Your Honor.
Defense?
We're just asking the court to accept the agreement. I think Ms. Santiago is in a good place and will be successful with what comes next. I think the jail sentence that she has served already will frankly cover anything that was not completed on probation. So thank you.
All right. And Ms. Santiago, is there anything you want to tell me before I impose sentence, ma'am?
No, I just thank you for, everything.
All right. Thank you, ma'am. Based on your admission, then I'm going to sentence you to 124 days in jail. I'm going to give you credit time served for 124 days. Ms. Santiago, the only concern is, of course, if there's a drug problem, this doesn't do anything to resolve or treat that. So make sure you get whatever help you need so that you don't wind back up here in jail, okay?
First move out of here is going to sober living.
Okay, I think that's a great idea. It's not a court order at this point because I no longer have jurisdiction.
No, she's not.
Honestly, you're more likely to be successful doing it that way than based on my order anyway. So good luck, ma'am.
Yeah, thank you.
She's
Thank
going
you.
right to that guy who said this is a waste of taxpayers' money. That's where she's going. She's going right there. Then they're going to get into a fight. He's going to call the police. Then later on, he's going to say, no, she's fine. I was joking. Circle. It's just circle. All right, guys, thank you so much for coming out today. I really, really, really appreciate it. I'll see you guys in a couple hours after I get off work. Hopefully I don't work a double. But I kind of do want to work a double. But I hope I don't work a double. That way I can do my stream tonight. I'm not scheduled for a double. Doubles just happen naturally. But we should be fine. I'll stream in a couple hours. I'll see some of you there. I'll see some of you tomorrow. Thanks for coming out, guys. Bye.
Well, I thought I'd write a happy song. I found a chat room where I belong. You don't know how much it means to me. With such a groove, I'm less lonely. Oh, Kathy's the creator. She's leading the way. At Court Vibes, we laugh and we stay. Her smile shines bright. She's got that grace. Come join the fun. It's a welcome and play. I can count on distraction from my pain. 'Cause this creator takes you there and back again. Kathy is the heart here, always in stride. joy she can't hide. Oh, Kathy's the creator, she's leading the way. At court vibes, we laugh and we stay. Her style is classy, she's always top shelf. Don't take my word, come and see for yourself. Her cases are new with a twist or two. I really like them, I believe you will too. A little lifeline passed along in rhyme. Why don't you join us? It's a guaranteed good time. Oh, Kathy's the creator, she's leading the way. At court vibes, we laugh and we stay. Her smile shines bright, she's got that grace. Come join the fun, it's a welcoming place. And so in conclusion, I'll wrap up this song. I hope I didn't miss anything that would be wrong. Hope I see you around. Don't stay on the shelf, join in the laughter. Come and see for